represent Betmaster Group. Betmaster is a casino and sports betting operator operating globally and out of Estonia, Malta, and Mexico. And we recently actually launched in Brazil. And we are one of the very latest who received a Malta gaming license just recently and about to launch next week. All right. So today, although I'm from an operator, we are only talking about blockchain. And we're talking about AML regulation in Estonia, which is where I'm from. I have 20 years of legal experience in corporate law, venture capital and technology, including gaming sector and also blockchain technology. And just recently, I finalized my research on PhD on technology neutrality principle and blockchain technology regulation. The cases that I researched were related to smart contracts, electronic signatures, shareholder letters, and also operating as a virtual currency exchange. There are some court cases, for example, HeadQuest and from Estonia, Autodevote, that are important case law in this matter. But today's topic is related to AML regulation in Estonia. And first off, I would like to talk about a principle that my PhD research was based on, which is about technology neutrality. You might actually need this principle in the future if you operate on the blockchain space. This is something you can use to argue your case with the regulators or argue your case in court, because it was a successful basis of winning a case of HeadQuest in the European Court of Justice. So technology neutrality principle argues that states should not pick a favored technology and then regulate to support it. States should actually allow the market to choose. And if there is innovators out there who come up with new technologies, then regulators should not pick favorites. Plus, the principle argues for this, that regulation should actually remain stable, meaning that regulators should come up with regulation that actually is sustainable, that does not change constantly. Because when you innovate, when you identify a business model on the market, and you actually put a lot of money into, like these startups, into developing something, and then the regulation changes completely, then you have wasted probably your money because you have to pivot. So the principle of technology neutrality is actually favors competition, and it favors innovators, startups, innovating markets. To be more precise, and you don't have to go into this because I know the font on the slides is very small, but in case technologies perform similar functions, equivalent functions, then the principle of technology neutrality actually obligates the regulators to guarantee that the effect on the use of this technology is also equivalent. Just giving an example of smart contracts. For example, electronic signature or any digital contract has certain weight and is recognized under European law, under member states' law. But smart contracts are not recognized in a similar way. And the reason primarily is related to the issuer of the keys. So the keys are not administered and issued by the certified issuer, because the protocol issues the keys. So this is a distinction that is related to functions. So regulators should actually analyze functions of technologies, and then they should analyze the effect of applying a regulation that already exists on that technology. So this is the principle of technology neutrality. And the sustainability principle, as I said, regulation should stick around, it should be long-term, and it should be sort of future-proof. And this all has to do with the hierarchy of how regulation is constructed. So if you have a very abstract rule, It will stick around for a longer period. If you have a very specific rule, it will probably be iterated more. It will be changed and amended constantly. So regulators should actually think how they come up with a regulation. On the regulation level of EU or directive level of EU, the obligations, requirements, functions should be always extremely abstract, and then you issue guidelines or standards in order to explain it in precision. The similar model was actually used for GDPR, those of you who know about the General Data Protection Regulation. So the standards about technical measures are not explained in the regulation. The standards of technical measures are actually dictated by the market, right? So this is the principle. The regulators' challenges with blockchain technology and with any technology is always that there is a pacing problem. Technology moves really quickly and regulators always move really slowly. And the Coleridge dilemma, which is about this, that regulators always want to interfere as early as possible because they don't want the market to sort of run away, and they're always scared of something new. And regulators also have the challenge that, as you have seen also in this conference, startups are innovating whatever sector, either it's gaming sector or it's financial sector. These are companies that have never been in the sector that are sort of crossing over. Telecom sector was innovatized by Skype, and a lot of the financial sector are now changed by the fintechs or startups that are also here in this conference doing blockchain and crypto. And regulators, of course, have a hard time understanding the technology, and therefore any regulation that they come up with might be very difficult to implement. So a brief overview of the things that the regulators had to sort of react to is Bitcoin, Ethereum, all of those other virtual currencies, ICO grace, security trade offerings, also DeFi and everything that came with it, and now NFTs. So regulators are sort of running after this train and are not able to actually be as innovative as the innovators out there. So the approaches have been of warning, clarifying, banning, and very few have licensed and supervised. And Estonia is one of them. So regulation development, this is actually in EU. In EU, in 2018, they introduced an AML directive that approached and addressed virtual currencies. And probably next year, they will adopt market of crypto assets regulation and also crypto infrastructures based on distributed ledger technologies regulation, which will change all of the member state regulation quite a bit. In Estonia, under this AML directive, when it was still a proposal, we already adopted new regulation for virtual currencies. Although, as I've added here as well, we actually did have our first case in the Supreme Court about virtual currency exchange service provider prior to that law entering into force, because we had a regulation about alternative means of payment. The law was supposed to address e-gold and e-silver, but also addressed Bitcoin. And there was this case that I researched. And Malta introduced their regulation, as far as I know, in 2018, shortly after Estonia. And both of these regulations were basis of issuing virtual currency exchange licenses and licenses in general for the blockchain technology space. Since that time, as I have put a comparison here, starting from 2008, when we still had the alternative means of payment licenses, until 2017, the law that was valid was changed 18 times. It's not easy to change a law. It has to go through the parliament 3 times, but over the period of 9 years, it was changed 18 times. The recent amendments that were done under which the virtual currency licenses have been issued in Estonia since 2017 have also brought about 18 times amendments in the law, which it means just that the law is iterated on multiple times per year. You might operate under law on Tuesday, and the law is different way Friday. So the subject categories in Estonia that have to gain and have to obtain a license are virtual currency exchange service providers. Earlier, since 2017, it was only virtual currency exchange against fiat. Starting 2020, it's also virtual currency exchange against another virtual currency. Also, custodial wallet service providers have to get a license, and issuers or organizers of virtual currency issue. In Estonia, starting from 2018, when we started issuing licenses, the first year already, there were more than 1,000 licenses issued, 600 in exchange services and 500 in custodial wallet services. The next year, the total number was already twice the size. You can't see the numbers maybe, but it's more than 2,000 licenses were issued by 2019. Then laws changed. Most of the licenses were revoked. And by 2020, we had only slightly below 400 licenses. The number is pretty constant now because we have about 444 licenses in 2021. And the plan to those changes that are coming by 2022 is that most of these licenses will be also revoked. There will be probably 10 left. The problem was that most of these companies operating in this virtual currency space had nothing to do with Estonia except that the company was established in Estonia. There were no teams, no taxes were paid, no management was in Estonia. And the regulation that is now about to change is going to introduce very, very stringent rules in order to sort of alleviate the supervisor's task to supervise these virtual currency companies. So, amendments starting 2022 will not only expand the subject list, but will make the requirements very similar to e-money institutions. It will have restrictions on individuals who can be compliance officers, who can be in the management, and etc. And it also will have restrictions in case you fail to receive a license, you can't come again to apply, reapply. There's higher fees, there's higher capital requirements, there's supervision fees introduced, and own funds requirements introduced. And no crypto is allowed to pay in those funds. So these are the numbers, if you can see. Again, you can't. But the share capital was increased up to 350,000. This is the minimum share capital for a virtual currency company in Estonia who wants the license. The state fee was increased to the level that no company or no license in Estonia has ever had such a high state fee, although it's not that big, it's 10,000, but still. And the own funds requirement is not a percentage, it's a sum. It has to be 350,000. And there is a supervision fee for the government. So are these amendments technology neutral is the question, because the restrictions are unparalleled. There's no restrictions similar for any license. There's our highest state fees in Estonia. License requirements are changing, as I said, very rapidly, and 18 times that this law has changed since 2018 is extremely high. And the license is similar to e-money license, but it's not passportable as an e-money license in EU. Furthermore, Estonian banks do not allow and mostly do not open accounts for any companies with that license. Thank you. Any questions? Do you want to come to Estonia?